Now call the Oldham County Code Enforcement Board to order. We have an open item first before we get to proceedings. Our chair has left the position, and now the chair position is now vacant. So the first order of business is to call for nominations for a new chair.
I nominate Clayton Raymer.
Any other nominations? Okay. Next order of business is to vote on the chair.
I make a motion to elect Clayton. Thank you.
Okay. All in favor?
Aye.
Okay. All opposed? All righty. The motion is passed, and so I am the new chair of the Code Enforcement Board. The next item on the agenda is to approve the minutes from our last meeting. Our last meeting was July 10th of 2024. And you all have the minutes in front of you all if you've had a chance to review them. If everything is in order, I'd like a motion to approve the minutes.
I make a motion to approve.
Okay, we have a motion to approve.
Motion to approve.
And a second. So all in favor to approve the minutes, say aye.
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 All opposed? All right, motion carries. So the next item on the agenda is citation number 809, California Dreaming LLC, Glen Oaks Country Club. We need to get everyone sworn in. It's going to be given testimony.
Everybody that's going to be given testimony, please stand, so that way we can get you sworn in, and raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give this board is true and accurate to the best of your belief and knowledge? Thank you. When you come up to the podium, just make sure that you state your name and your address.
Good afternoon, everyone. So our first case today is citation number 809, Glen Oaks Country Club, 10601 Worthington Lane, Prospect, Kentucky. The owner on record is California Dreamin' LLC, care of James Miller of 325 West Main Street, Suite 2000, Louisville, Kentucky. This hearing was requested. This is a copy of the request for the hearing signed by Daniel Wilhelm. He is the manager of the Glen Oaks Country Club. He did sign it and handed it to me on August the 19th of 25. So this citation evolves mostly around the driving range of Glen Oaks Country Club. You can see it on this map. It's the area in the center of the picture, and evolves around the houses on Laurel Lane, 5 residences on Laurel Lane. So this is a violation of the Oldham County Nuisance Ordinance. It states a nuisance is any condition or use of premises or a building exterior which is detrimental to the property of others or which causes or tends to cause substantial diminution in the value of other properties, or, and it's highlighted here, which renders such properties as dangerous or detrimental or adverse to the health, welfare, or offensive to the senses of the residents of Oldham County. And then it goes on to include the scattering of debris along the property. So a little bit of case history on this property. So in 2021, and I don't want to go into this one in great detail, I wasn't the code enforcement officer at this time, but in 2021, code enforcement received complaints from some property owners on Laurel Lane about golf balls entering neighboring properties. It doesn't appear a case was ever opened, but there was dialogue between code enforcement, planning and zoning, Glen Oaks Country Club, and several neighbors that I'm aware of. So in 2022, in April, our office received complaints about golf balls hitting neighboring houses and that the number of balls coming into their yards were unacceptable and making it unsafe for them to enjoy their backyard. I did issue a citation on April the 21st of 2022 for a violation of the nuisance ordinance. This citation was hand-delivered to Daniel Wilhelm. The citation was withdrew per Jim Urban, the previous planning and zoning director, after we had several meetings with the neighbors and Glen Oaks Country Club. So a few notes from those meetings and what occurred in 2022, which this case goes back quite some time. In May of 2022, on the 2nd, I spoke with Daniel Wilhelm. He said that they have installed signs at the driving range, started a program to track people at the driving range, and he wasn't sure what else to do, that he would contact Jim Urban to discuss the issue. He called Jim and informed him, Jim did inform him to look into possible netting and set up a meeting with the neighbors sometime around the 18th or 19th. On May the 4th, I spoke to Scott Saylor. He is one of the owners of the property on Laurel Lane. He informed me that 2 golf balls had come onto his property, one at 8:30 in the morning and one at 10:44. I did inform him of the meeting on May the 19th. He had already known about it. I think someone else had reached out to him and some of the other residents on Laurel Lane. I did receive several other complaints about golf balls. Not all of those did I write down. On May the 5th, I spoke to Scott. He was going to get with the other neighbors to fill out an abatement of nuisance form, which they did do. On May the 12th, we did have a meeting with Glen Oaks Country Club. Present was me, Jim Urban, Daniel Wilhelm, Scott Saylor, Jack Cooney, and Casey, all 3 of which reside on Laurel Lane. And there were some other members from Glen Oaks Country Club there. Glen Oaks and the homeowners agreed to try irons only at that time, except when the instructor was giving lessons. Glen Oaks also was going to set up a text message system for the homeowners to contact someone on site to address when errant balls as they occurred. Daniel was going to look into, and I apologize if this is wrong, I'm not a golfer, but something called low fly golf balls. I believe these are golf balls that don't quite go as far. Glen Oaks did ask the homeowners about netting. Both parties agreed that it was not the best alternative. We were going to meet again after July the 4th weekend to discuss if new policies were helping. On July the 6th, I spoke to Casey Howe. He is one of the residents on Laurel Lane. He stated that he was still receiving an unacceptable number of balls in the yard. He felt that the issue of no woods was not being enforced well enough. He said the golf course had been responsive when texted, but by then it was too late. On July the 7th, I spoke to Jack Cooney. He called. He stated that there had been a huge improvement. Homeowners met and would like to schedule another meeting with the golf course to discuss a little tweaking of the irons-only policy that might get golf balls to an acceptable number for all the residents along Laurel Lane. He was going to email me and Daniel to try to choose an available date. On October the 21st, we had scheduled a meeting between July and October for October the 20th. On October the 21st, I did note that we had to cancel this scheduled meeting for October the 20th. I spoke to several of the residents. Most of them had said that it had been much improved since the last meeting, but that we would check back and get together the next spring when golfing started back up. On March the 23rd of 2023, we did hold another meeting at the country club. Jack Cooney, myself, Jim Urban, another resident from Laurel Lane, Scott Saylor was there. Scott Saylor, Jack Cooney, me, myself, Daniel, Jim Urban, and I believe there was 1 or 2 other ones from the golf course there. Jack Cooney had been satisfied with the irons only. He asked if it would continue. Daniel replied yes, unless he was told otherwise. Scott Saylor was fairly satisfied, asked about having a monitor at the driving range. Daniel stated at that time that he was trying to hire someone, but was having no luck. They were going to try to send out some kind of an offer into the subdivision to see if anyone was interested in the HOA to work the driving range. Casey was not present at that meeting. Daniel also, at this time, he did offer netting to anyone of the residents that were interested. I think they were going to try to put them in the trees to limit the number of balls that came through that were being affected. At that time, we did bring up the low-fly golf balls, but apparently that was not an option due to the current cost and the availability. So after that meeting, all the way up until July of this year, so for approximately 2 years, I had received no new complaints. So that case from 2022 was pretty much, it was dropped. In July of 2025, I received a call from Jack Cooney complaining that the golf ball issue had gotten worse. After I spoke with Director Ryan Fisher, I informed Jack to have the neighbors fill out a new abatement of nuisance. The abatement of nuisance was delivered to our office the first week of August. And I do have a copy of the abatement of nuisance, and you also have that in your packet stating the issues that they were having. So I did go out there, and I'd like to start with 6119 Laurel Lane. I did some measuring on our GIS map. So 6119 from the tees to the backyard is approximately 826 feet from the tee. This is a picture from the backyard of 6119. That's me. So there's some tall grass from their backyard going to where the driving range is to try to slow the balls down from rolling into the yard. There are a few trees, so sometimes I had to kind of step into the trees, and I'll show some of those pictures as we go along. But this is a picture looking towards the driving range. It's up on the left-hand corner. This is a picture of, I did find 2 balls on his property that day. Both of them in the mulch beds. You can see them in these photos. 6121 Laurel Lane is approximately 754 feet from the tee. This is a picture from their backyard. Once again, I have stepped into the tall grass area to kind of get a picture towards the direction of where they tee off. They are, I don't have an arrow, but they're back there up on the left-hand corner. I did find a total of 63 golf balls in the backyard of this property. I will state that some of them, as you can see in these 2 pictures, looked like they were laying on top of the ground. Some of them were pushed into the dirt pretty good. It looked like they had been there for some time. But I did find 63 golf balls. These are a few other golf balls. One of them up on the back patio at 6121. You can see that in the right picture right there. 6123 Laurel Lane is approximately 679 feet from the tee to the center of their backyard. This is a picture looking towards the driving range. I found 5 golf balls in the backyard that day. Here's a few pictures of some of them. 6125 is 613 feet from the tee. So the picture to the left here is me standing in the middle of their backyard, and you can kind of see that there is some trees. And then the picture to the right is me kind of stepping through those trees onto that tall grass line to be able to, so that you can see a visual of the driving range. There, on that property, there were too many golf balls for me to even count. They were all over the yard. But I did take a few pictures of some of them. I did find several golf balls on the deck of the back of that house. 6127 Laurel Lane is approximately 541 feet from the tee. So the picture on the left is me standing in the middle of their backyard looking towards where they tee off. And then the picture to the right is me stepping through those trees into that grass, the beginning of that grass area, so that you can get a better view of them teeing. I believe the tees, if you look at that picture to the right, it's behind that evergreen tree. That's where the tees are, the majority of them. I did find 6 golf balls in their backyard. Here are a picture of a few of them. So the homeowners, this is a picture of damage that they showed me on their house that was caused by the golf balls hitting the home. The picture on the left is a hole in their upper deck. It's a second-story deck. You can see the hole in the deck. And the picture on the right is on their siding. So these are a couple view from the tee boxes looking towards. The picture to the left is looking down the driving range. The houses that we are discussing would be on the right of that picture, behind those trees right there. And the picture to the right is looking directly at, and I believe that's 6127. And again, that's standing at the tees looking to the right. And just to give you an idea that there is a tree line there, but the balls are coming through the trees. But you can see the White House behind that. I did issue citation 809 on August the 19th of 2025 for a violation of the nuisance ordinance. The citation was hand-delivered to Daniel on August the 19th. Daniel did request the hearing at that time. The notice for the hearing was sent to all parties involved, so I did send the notice out to Daniel and all 5 residents, and it was also posted in the Oldham area on September the 25th of 25. So this is just a better aerial view of the houses in question. So you have 6127 being, if you look at the bottom left over here, you can see where the tees are. And then you have 6127, 25, 23, 21, and 19 Laurel Lane going down that right-hand side. And this gives you a picture. There is a little bit of a tree line there. The brown area would be the taller grass that's not being mowed to try to keep some balls out, but they're still getting quite a few on the property. Y'all have any questions?
I have a question. Did you note any other damage, or was any other damage reported to you besides the 2 pictures we saw?
That was the only damage that I did see. I was reported that, I believe, and I apologize if I'm wrong, but I'll let him talk about it more. I think it was Scott Saylor did say that one of his taillights on one of his vehicles was busted out. And they have said that they do find golf balls in the front yard. I did not find any on the days that I were there, but all 5 parties said that the golf balls do come in the front yard rarely, but it does occur, and they also end up in the roadway. But I will definitely let them talk more about that.
Okay.
I have a question. Has anybody been hurt?
Not that I'm aware of.
Have there been any complaints before 2022?
So I became the code enforcement officer in January of 22. So if you go all the way back, there was a complaint prior to that. I don't know the exact date because I wasn't the code enforcement officer at that time. There was communication between the code enforcement officer. No case was opened. But I know there was communication because the previous director, Jim Urban, when I got the complaint in 2022, he was aware of the situation. And I believe they had discussed and had meetings with the golf course prior to that. And I think the golf course may have done a few things, lessened some tees. I don't want to get into it a whole lot because I don't know what was done. But you can definitely talk to them and ask them what's been done, and same way with the complainants regarding the complaint in 21.
Anybody else? All right. Thank you.
Yes. Have there been any incidents of subsequent damage, like mowers hitting the golf balls and throwing the golf balls from underneath the deck?
Not that I'm aware of. Again, that's definitely a question for the property owners, but nothing that I'm aware of.
Okay, thank you.
Does anybody have a preference on who wants to go first? You all? All right.
Thank you. My name is Scott Saylor. I live at 6123 Laurel Lane, Prospect, 40059, with my wife, Robin. We've been residents of Oldham County and Glen Oaks since 1999. I'm a retired electrical contractor. Of those represented here today, we have been Glen Oaks residents the longest. My home backs up to the driving range, and like the other families here, I share my back property line with the driving range. They're my neighbors. When we first bought our property in '99, the original operator was running the business as a private golf club. There was no problem with balls hitting the house or even landing in the yard. At that time, Glen Oaks was a good neighbor, but unfortunately that operator went bankrupt, and Northwestern Life, I think was the name of the insurance company, ran the club during the bankruptcy period. Northwestern was a responsible operator, and the driving range was irons only and operated as a private club. California Dreaming and Jamie Miller bought the course and are the current operators. Since being taken over by California Dreaming, we've been bombarded with range balls landing in our yard, hitting and damaging our homes, endangering the residents and children. In addition to balls in the backyards, at least 3 of us are getting balls hit over our homes and landing in the front yards and on Laurel Lane. There have been 3 instances on my property where balls nearly struck individuals. One incident involved a ball coming close to my wife while she was working in the backyard. Another nearly hit me in the driveway in the front. And a third ball came very near my 4-year-old granddaughter, also in front of the house. Since late 2020, we have counted 274 balls in our yard, 10 balls on Laurel Lane, and 21 strikes on our house. And I'd estimate that these figures are only about 85% of the actual occurrences. In 2022, after being constantly hit by range balls, the neighbors contacted Oldham County to help us find some relief. Judge David Vogel got involved in a process, and soon after, there were meetings between the residents and California Dreaming. These meetings were conducted by Jim Urban and Adam Bayer with Oldham County Planning and Development Code Enforcement. At these meetings, it was decided and directed that the range would be irons only. A text group was established to report errant balls, and that arrangement worked well. In the early summer of 2024, an increase in stray balls led the club manager Daniel Wilhelm to post irons only signs on the range. These signs immediately stopped the errant balls to almost nothing. The summer of 2024 was the best we've ever had. During the summer of 2025, we began experiencing recurring incidents involving stray balls. After several discussions with the club manager, we learned that irons only signage had been removed. Furthermore, Jamie had decided that he is no longer going to honor the agreement that Oldham County, the Glen Oaks residents, and the Glen Oaks Golf Club agreed to previously. One day early this summer, I was sitting in front of the house when a ball landed in the street. A minute or two later, a group of kids walked by heading up to the pool. So I started counting the number of pedestrians on Laurel Lane, and it's approximately 34 per hour, mostly kids heading up to the club pool. Not only is Jamie Miller endangering the public, but he is hitting golf balls at his own members. Somebody's going to be seriously hurt, if not worse. My van has been hit twice, leaving a dent on the hood and a broken taillight. The broken taillight occurred right before we were to leave for a family vacation in North Carolina this summer. I came out one morning to find that the taillight had been broken by a range ball. Not wanting to drive with a non-functioning taillight, I purchased a part online and my son and I installed it. I contacted Daniel and asked to be reimbursed for the part only. When I called a couple of weeks later to find out when I would receive a check, Daniel told me that Jamie would not pay the invoice and that the offending golfer was responsible. I mean, how am I to find that golfer? There has also been untold damage to our homes, such as broken windows, damaged trim, dents in garage doors, and broken roof shingles. The land that the driving range occupies is approximately 1/3 too small of what would be required by today's standards. Advancements of balls and clubs has only made the situation worse. It is my opinion that the Glen Oaks needs to return to an irons-only policy immediately and that the club employ a monitor at the range with the authority to remove the offenders. We would like the club to keep names, dates, and times of purchase for anyone buying balls for the range. We would also like the county to impose a fine for every errant ball like the system the county implemented in 2022. We want to re-implement the text change with the added requirement that the club respond to the text within 5 minutes and an explanation or resolution within 30 minutes. In closing, I'd like to thank you for the opportunity to speak today. It's not our intention to cause a hardship on the golf club. All we are asking is that the club respect us as neighbors and not endanger the residents, their children, their property, and the enjoyment of their homes. Thank you.
Any questions?
Would you mention that when you first moved in that it was privately held and there was a private, it was the golf course was managed privately, and then it went to California Dreaming, and
There was an operator first, and I don't remember his name. They went bankrupt very shortly after that, and then an insurance company came in and took over the golf course while it was in bankruptcy.
okay, you also mentioned that you were satisfied when the private enterprise owned the golf course, and then when the insurance company took over, that's when the problems start. Is that correct?
No. The insurance company pretty much had the same. I would think they had the same management, but there was not a problem.
Okay.
Until California Dreaming took it.
Yeah, so that's what I'm saying. So the problem started when California Dreaming took over, right? So what changed from the private management versus California Dreaming as far as the golfers go?
Sir, real quick, could you speak into the mic? We're having trouble hearing.
Oh, I'm sorry.
Thank you.
What was your question again?
What compared to the private enterprise that opened the golf course or that owned the golf course prior to California, or is it? I keep saying California Dreaming. What was the difference with the golfers? Because the golfers during the private, when they owned it privately, you didn't have this problem.
It was irons only.
It was irons only. Okay, that was my question. Okay, thank you, sir.
I have a question. When it was irons only, were you still getting any balls in your yard?
We would get a little bit on the edge of the yard. All of us have let our trees and all the bushes and stuff grow out there, and then and the club manager also gave us. There's an area there where they don't mow, and that stops a lot of the rolling balls. The balls that we get are are hit by drivers, and most of them go over the trees. So netting's not an answer. Most of it is just stuff that a lot of the balls that hit obviously hit out front and hit on Laurel Lane are going completely over the trees and over the houses.
Would you know on average about how many you get in your yard a day?
It just depends on how much business they're doing.
A busy Saturday.
Well, like I said, we've had since 2022 we've had 274 balls in our yard.
Over the 3 years?
Yeah.
Okay.
Yeah. Now, it quieted down quite a bit after the meetings we had, and they went to irons only, and that solved the problem. We were all able to work it out.
How long have you been at the property? I don't have
Excuse
that.
me?
How long have you lived at the property, at your
1999.
1999. And is it correct you were saying it really wasn't a problem until like the 2022 timeframe?
Yeah. Well, yeah. Right. 2022. Right before that. Yeah.
Do you know if it was irons only between 99 and?
From my understanding, it was irons only by the previous owners.
Okay.
Do you have a financial number of the damage to your house?
No, I mean, I haven't had any windows broken. The worst, the only real damage here in the last couple of years has been to my car. And I've spent a couple $100 on that.
And did I hear correctly, for you, the solution is no woods and then make sure there's monitoring and some sort of fine if the county can make that happen?
Yes.
Is that's what you're seeking as far as the homeowner? Okay.
Yes, sir.
Any other questions?
Yeah. Excuse me. How do you feel when you walk out in your backyard?
Well, I don't go in the backyard.
You don't go in the backyard.
And I don't know. And I don't let my grandchildren go out in the backyard. And actually, we have a lanai in the back of our house, and it's a nice screened-in porch. And I don't go out there because, in a few years ago when we were getting hit a lot, it was just too nerve-wracking to hear a ball hit the house or come through a screen and or bounce in the yard. And so we rarely use that room now.
Okay. Thank you.
Thank you.
Thank you.
My name is Jack Cooney, and I live at 6119 Laurel Lane. Of those who signed the petition and those that are here, I'm the furthest out, the furthest away from the drivers. And that puts my edge of my property about, let's say, 275 yards. And to my porch, it's another 25 yards. And unfortunately, with the advancement of equipment over the years, fairly good hitters have no problems with that distance. So I've been at the home since 2002. So I've been there 23 years. Again, I'm the furthest away. I'm the furthest away, so I get the fewest number of golf balls. And I have kept records in past years. Things did get better, and I stopped keeping records. And so just recently, I started again. It's a slow time, so there's not many here, but I'll hand this out. Thank you. Again, that's not a large number of balls. I also have very mature large trees in the back of my home. And that blocks, especially when the foliage is vibrant like it is right now, that protects my home quite a bit. Nevertheless, there's still occasional balls that hit the house, and I'll find in front of the house. So. I direct your attention to numbers 1 through 4, and I have more handouts. Numbers 1 through 4 have been discussed to some degree earlier. And these constituted the informal agreement that we had with the club. It was pulled together after several meetings at the club with residents from Laurel Lane, the club, and Jim Urban and Adam Bayer. And each of these is helpful. Nothing is perfect. Each is very helpful. The first one, irons only, seemed to be the most beneficial. And what has happened earlier this year is the driving range said, well, we're not going to accommodate number 1 anymore. And then when the county delivered the citation to the club, they said, we're not going to do number 2 anymore. And that's communications via text, which proved to be much more efficient than trying to call people on phones. And it's a group text, so it proved to be quite helpful. So would certainly like those items reinstituted. By the way, some of these items were requested by the residents and some were offered by the club. Yeah, there had been some good communications. And while the informal agreement was, Oldham County was not party to the agreement, representatives of Oldham County brought the parties together, which was very helpful. So, and question had been raised, what might help further, and that's down below, a framework for additional actions to improve safety. So, and we'll gladly discuss that at the appropriate time with the appropriate parties. So, the Adam made clear that a nuisance is when conditions produce a dangerous effect. Golf balls falling around family members is dangerous, period, black and white. It is a nuisance, and it's a repetitive nuisance. So, thank you. Any questions? Sure.
That question, just a second. How long have you lived at the property?
23 years.
23 years. Was the driving range there when you purchased the home?
Yes.
Okay.
Yes.
Was it an expectation that a few balls would
I did get some balls, but they were infrequent.
okay. Yeah. Any other questions? Nope. All right. Thank you, sir.
Thank you.
One second. Can I? Who would be the manager of California Dreamin'? Let me have you come up real quick. I imagine a lot of what everyone's going to say is going to be very similar, and we can get to them in just a second. I just wanted to ask a couple of questions that seem pretty pressing. One, was there an agreement reached about using iron?
Verbal. Daniel Willem, General Manager, Glen Oaks Country Club, 3219 Highway 1694, Crestwood, Kentucky.
So you did reach an agreement?
Verbal arrangement.
Okay. So
No timeline or anything like that. Just verbal agreement.
Okay. And what is why change that agreement? Why allow woods now?
We always had. So what the other two gentlemen mentioned was before ownership with Jamie Miller and California Dreamin'. Shortly after he purchased it, we did a remodel of the T line up above on the screen when I say above. Under previous ownership in the previous construction of the range, there was 4 separate tee boxes, 2 of those tee boxes being closer, more out into the field. Those 2 tee boxes were irons only under previous ownership of Pacific Life, not Northern Mutual or whatever, Pacific Life. I've been employed at Glen Oaks since 1998.
1998. Okay.
Range was constructed and built in 91.
All right. That was the main thing I wanted to know. I mean, you can give your testimony here a little
Yep.
bit. I just wanted to. That was the second time we'd heard that, and I wanted to ask that question.
Sure.
So we'll give you another chance in just a second. I believe you were standing up.
Name's Sean Webb. I live on 6121 Laurel Lane. I don't have papers to present or anything like that. I just wanted to say a few things that were not mentioned here already. Windows that were broken were mine, actually. We moved there in 2020, as you've been asking that question. And we bought it from my wife's grandmother, our home, before it changed ownership to the current owner. The grandmother, my mother-in-law, didn't seem to have a problem with her property. There weren't a ton of complaints. When we took over the property in the first year, 2 windows were broken. The cost about $1,200. Again, same thing as our other residents here. I don't feel comfortable with my kids going out in the backyard. I've had them land near me several times, near my wife. They landed across our house in the street. I've had siding damaged. And you can see I've tried to repair it as best I can and things like that, but it's just not a safe place to be in my backyard, and I want my kids to be able to play and enjoy our property in a whole. The question was asked, has anybody been hurt yet? I don't think that's a relevant question. I think that the important thing is it's just a matter of time. I think that it's going to happen, and we want to stop that from happening now, as opposed to letting it happen later.
Any questions? Thank you, sir.
My name is Casey Houlet. I live at 6125 Laurel Lane, Prospect, Kentucky. My wife Amanda and 3 children, age 16, 9, and 9. Our property backs up to the practice range of the golf club. When we purchased our home in the fall of 21, it was a slow time for the range, and the previous owner of the home downplayed the errant golf ball situation. If we had known the true extent of the hazards and neglect of the situation from the club, we would have never bought the house. We are only asking for a safe backyard that we can enjoy and our kids can play in without fear of getting hit by a rogue golf ball that should be contained properly by the club. I'm afraid it is only a matter of time before one of our children is injured from a golf ball. It is also realistic to think it's only a matter of time before someone walking down the sidewalk or driving their car on Laurel Lane is struck by a golf ball, causing personal injury or vehicular accident. I have over a dozen large dents from golf balls in my garage door. All of those could have easily struck one of my family members. We should be able to sit on our back deck or play basketball in the driveway without having to be mindful of golf balls flying at our heads. Our kids only get one childhood, and it should not include fear of being struck by golf balls simply because they're playing in their backyard. There have been countless days the kids have had to stop playing from fear of being hit by golf balls. My neighbors and myself have had to stop playing with our kids on several occasions in order to try and get the attention of golfers on the range in an attempt to get them to stop hitting drivers errantly in our direction. My children have become leery of playing in their own backyard. That is very sad truth we are now faced with. All we are asking the club do is the right thing and be a good neighbor to the residents of Glen Oaks. The decent thing here would be to make sure they contain their business on their property and let residents enjoy their homes without fear of personal injury or damage to our property. The club has at times countered our concerns with the stance that we chose to purchase a home near a practice range. While that is true, the club chose to build a practice range in the middle of a neighborhood, and they should be responsible for containing their business within their borders so the residents can enjoy their private property without fear of injury or damage. The most logical answer would be to install professional netting like I see at every other practice range around the city. If professional netting is not possible, the next best solution would be the enforcement of irons only on the range. Enforcement is the key issue. Having signs posted is not good enough. The club should have a mandatory range monitor physically on the range at all times, enforcing the irons only policy in order to protect the residents from errant golf balls, since the club cannot or will not ensure golf balls stay contained on the range. Thank you for your time and considering our concerns in this matter.
Any questions?
Yeah, I have one. Do you know about how many balls you get in your yard every day?
Every day is a tough one to pin down. We could easily get double digits a day. And we might be playing and it might be 2, 3, 4 balls in a row. And there's other times, it could be hours with nothing. So it's not consistent. You couldn't say a couple balls an hour. It goes hot and cold, but when it's hot, it's scary.
Thank you.
Thank you, sir.
Hi, Board. Mike McNatt. I'm at 6127 Laurel Lane. Just quickly to address some questions about has anyone been hit or has there been any damage from lawnmowers? So like the rest of the residents, we don't use our backyard much, especially when the range is open because we don't want that to happen. It is a real possibility. So I think part of the reason no one's been hit is because we don't go back there. And then for grass cutting, I always pick the yard. I have to walk and pick up golf balls before we actually do it. So to try to avoid all that good stuff. So the picture with the dent in the side of the house was ours. The big issue is that living on a range is different than living on the golf course. When you tee off on a hole in a golf course, you have to go past that house to either get your ball or continue on through the course, right? On a driving range, you could hit 30 balls and you never go anywhere near there. There's never any yellow 4, right? If you're on a golf course and you are hitting towards a house or towards a person, there's always some kind of heads up. That doesn't happen on the driving range. I've got 2 kids, a 10-year-old, 13-year-old. You know, there are many times when Casey and I are out with the boys trying to play baseball and balls are flying in. So, you know, again, I can speak for myself and my wife. We don't want the range or the golf course to shut down. That's the last thing we want, right? We want it to be there to be enjoyed by folks. We just want a solution that we can enjoy our backyard and not feel like we're in danger. And I think the irons only is a great idea. The text string solution sounds great in theory, but as Casey alluded, I think the last text message that we got on that text string, the advice was, you bought a house on the range. That's not helpful when we're trying to track someone down to hit our house, right? So I think there's got to be some impact to golfers that do it. Right now, I don't believe there is any. You know, it's us yelling at them to put it away because we're getting hit at. I don't think that there's much on the golf side. So appreciate your time. September of 2017 is when I moved in. Similar to Casey, kind of got the raw end of the deal when we asked about balls. You know, we were there for, I think we came twice to see the house. There may have been 1 or 2 balls. And then I even asked at our closing, do you get many balls? And the answer was no. Come to find out, that's definitely not the truth. I don't know. I know you've been asking how many balls. So I collected balls in my yard for the last 3 weeks. But, you know, there's 30 some odd balls there. And this is, so I live at 6127. The back, I think what got shot was about less than 200 yards. So these are balls that get through the grass, over the trees, and into the yard. And I think some of the pictures where, you know, they're in the rock up next to our house by air conditioner, by door. And so it's frightening, honestly. And I think the big thing is there's just never time to actually go in the backyard. Golfers start at 7 a.m. and there are people on the range, even though it is likely closed, out there getting balls from the range and hitting them, whether it be from the actual range itself, or there are many nights that folks get balls off the practice range that you can see in the bottom right and are hitting back to the range, which is, again, even closer to our houses if it's an errant shot. Thank you.
You have any questions?
How do you feel this is going to affect your resale value if you ever tried to sell?
If I'm being honest, of course, yeah. If I lie like the folks that we've talked to, but I don't plan to do that. Yeah, obviously.
How do you feel it would affect your house, your resale value?
It absolutely would. Like Casey said, I don't think that I probably would have moved in with 2 kids if I knew we were in constant potential to get hit with balls. So.
Okay. Yeah. Thank you.
Any other questions? All right. Thank you, sir. Anybody else? Okay. Who would like to speak in against the citation?
Hi, my name is James Miller. I'm the managing partner of California Dream in Glen Oaks. I grew up in Louisville, Kentucky. My wife's from California. The dream was to get back to where her family was.
Can we get your address, sir?
1371 Gordon Lane in Santa Rosa, California.
Okay.
But again, I'm from Louisville. I grew up here and very familiar with Glen Oaks. I played golf my entire life. I think I want to address one thing Mr. Saylor said. He is correct. It probably wasn't that busy. The club went into bankruptcy. So part of our job when we bought the property in 2016, there was the original developer, HFH, which also designed and built Glen Mary, a few other golf courses in the Louisville area. Glen Oaks was one of those properties. The original developer made it through that process. They sold it to another entity after that. That was the one that went bankrupt. and then Pac Life took it over. So there, just to give a clear indication of ownership. At that time, it was private. At the time we purchased it, it was doing 17,000 rounds, which in golf terminology is not that many. Seneca Golf Course does probably 60,000 rounds. So part of my job with a bank loan, a new bank loan from a public bank, was to make sure that we were able to pay that note, meet our obligations. And the driving range is a big part of that. We have a membership called Practice and Play. Half of that is practice. Some folks join this membership at $69 a month to hit golf balls. That's what they came to do. So Mr. Saylor's right. All these guys are right. There's more activity. And the conundrum is that Oldham County has allowed this to be zoned R2A, with conditional use as a golf course and a driving range. Oldham County has also said that they can have a home next to this same thing that we're managing as we're told to manage it. So the question is really, are we being negligent? And we have done, I think, to the best of our abilities, many of the other techniques that we use on the golf course. So this small tract is about 10 acres. We have 200 acres in total, 100 of which are in the Oldham County side, of which there are about 300 homes that are along the golf course or adjacent to the golf course, of which none have ever filed any nuisance complaint the entire time. Now, we're doing about 30,000 rounds annually on the average. It's some years we've done 38, some 25, but the average since we've been there for the 9 years has been, I'd say, 30. So you're talking about well over 250,000 rounds of golf. So I agree with Mr. McNatt that there may be some people up there, but there's been over 250,000 people that have played the other 100 acres that are part of this golf course that nobody's ever heard from in terms of Oldham County code enforcement. Now, it's my job to make sure, to work with Daniel and the team there on the golf side, that we do everything we can. So yes, we've grown up the rough on the right side for the ones that are jumping along the ground, hopefully stop them. We've moved the target areas, which has not been mentioned. There are flags, and you can see kind of mounding where greens would be for golf terminology. We've moved those to the left or to the north, so that shots then would have a less of an opportunity to be hit to the right. We did that very early on. That has not been shared here. To Daniel's point, we closed the driving range tees that were ahead of this big tee box that you see there. I took the tennis court out so that we could use the right side where the tennis court was to angle more hitting north instead of to the south, which is where these homes are on that map. So we've done that. We've also moved, there are several small netting areas that were moved to the north, buckets where people can hit into with nets on the bottom. Again, hoping that most people, if you give them the right target, will aim in that direction. We've put really good signs that say it is your responsibility as a golfer, that if you hit a ball towards a house and damage property or person, that you are liable for that. We've also put up 2 cameras that are web-based, and we have every access to them at any point during the day. They're similar to the Lorix cameras you see at Costco that allow us access at any time of the day or night, to see if there's somebody up there or if somebody's misbehaving. So we've done quite a bit, and we're willing to do more. The issue I have with Irons Only is this is a big part of our membership. There are over 600 people that have taken this membership, of which hitting golf balls is an important part of it. So yeah, there's going to be more activity, and therefore we have done some of these measures in order to try to alleviate what's inevitably going to happen. The conundrum is that it's going to happen. I think there was somebody in their group that stood up and said any ball is unacceptable. I don't think that's quite possible no matter what we choose. Irons Only can reach at least 3, if not 4 of the houses in today's world. So in order to keep my membership whole, in order to offer what everybody else is offering in Jefferson and Oldham County in terms of practice range privileges, and in the fact that I've been offered that zoning code through Oldham County, the conundrum is we still can have personal and personal damage to injury or property damage. And I'll give you two other examples of things we've done that I've never been asked to do from these folks to the right of me. Dot Troji lives on the second hole of the golf course. Again, since she's lived there and lived there the entire time we've been there, she's over 90 years old. She approached me, I'd say well over 5 years ago, and asked me, somebody hit the golf course, hit our house with a golf ball. He's in a red shirt on cart 42. Call Daniel. I went out there and I was actually living there at the time. When I'm home sometimes, I actually live at the club. Went out with Dot Troji. We found out who the person was, and we ended up approaching them at their house. That guy volunteered, well, he had to because we busted him, that he had to fix the property, and he did. So that's an example of property damage that it's not going to be every time that we can get it, but with the cameras and help from them, the property owners on the range, we can do that. As far as personal injury, I have a more real example of what Mr. McNaught and Mr. Hooley were giving, which is the Steele family, which lives on the 10th hole, is at the corner of a dog leg, which is a very normal place to get hit on a golf course. These same 250,000+ people that have played were hitting his house all the time. And he's got young kids, just like these gentlemen do, and their wives. He approached us and said, you know what? I know we live on this thing, but I got to have some help. Do you have any ideas of netting manufacturers? And can you help me, show me, as I'm not a golfer, where it can go? Absolutely. We went out and we found some netting that would work for him. We helped him locate it in the trees, and he then put it up in the canopy of the trees, and we haven't heard from him since. That's an example of somebody taking responsibility and working with us in this conundrum of we've been zoned a golf course and a driving range. They were allowed to buy a home and build a home there and live there, and we worked together to find a solution. So what I'm going to posit here is I'm perfectly willing to keep trying to work with any property owner, not just the ones in the driving range. We're here and committed to make this property better, and we have. Home values along Laurel Lane on either side of that are well over $500,000. These homes probably started at 200 and change back in the time they were bought. The conundrum is, again, this was built in 1993. None of the people that are living here bought before 1999. So they were well aware of it as a driving range. So what I'd like to propose is, and what I'd like to hear from them is, and I have not heard it, is we have done quite a bit to try to mitigate and work with people on getting this stopped as much as we possibly can. I cannot guarantee one ball, and that's going to be the problem. The issue I have is I've not heard one thing from them, and neither of you, of what they've promised to do for themselves to protect their own families and their own property. We have offered them netting at one of the meetings. I have netting from Southern Sports, which is a closed driving range run by the Smith family off Preston Highway, and we have a lot of it. And I was willing to give it to these property owners, wouldn't take it. I am willing to help, but we have a business to run in order to keep the property values of everybody else and ourselves to pay our obligations. And so that conundrum is there's going to be balls, and I don't know how to completely stop that under the current zoning that we both share. Again, I'll say it for the last time. It should be considered that nobody in this room or in this committee has heard one thing that they've done in order to protect their family, knowing that they have some assumption of risk in this situation. Thank you.
All right. 1 second, sir. I'm sure we have questions. One of the questions I have is with the irons only, the change back. What was the motivation for changing back?
We were getting complaints from guests. They bought this membership hitting drivers. Then they're irons only. Then there's drivers. Then there's irons only. And I finally just said, look, we're still getting the complaints when there's irons only. So there's balls in their yard. So we continued to do what we did. We installed an extra camera. I think like I said, we have 2 up there now. We're doing what we can in order to provide our guests what we promised them, a driving range. A driving range implies that you're hitting your driver. That's what most people want to do. Now, I perfectly agree. They should be responsible, 100%. And we have proven in other situations, as I've outlined, that we can find these people if they will help us. What they typically do is text and say, there's somebody hitting a golf ball in our yard. All I've asked is give us the other information. Is it a guy in a green shirt, a white shirt? Are there 2 guys up there? Can we locate the people that are doing this. Sometimes it can only be two things. Either you're intentionally doing it or it's an accident. If it's an accident, most people, sensible people, are going to say, hey, I'm really sorry. You know, I won't do that again. If it's intentional, we'll throw them out of the club. I have no problem standing on our club rules to say you can't hit balls intentionally at somebody's house or somebody. But we have to be able to coexist under the current environment that what we've both been zoned to do. They've been zoned and to live there and have their family, and we've been zoned to have a driving range and operate it as a business.
Anybody else have any other questions?
You mentioned that you have a camera and you saw somebody hurt a house and hurt an older lady's house, and you went and ran him down and you made him pay for it, or say he was liable for that. And you also mentioned that every golfer knows that they are liable for any damage.
Most golfers should. I probably shouldn't have said all. Most golfers understand that the clubs themselves, I can't find any case in America. There was one in Massachusetts, and it was on appeal, and they lost. Every time this situation happens that I've seen, and this is my business, this is all I've ever done. The club, if they are not negligent, are not responsible. It's the golfer themselves that struck the golf ball. And so we've made every effort in all these cases. Give me the cart number, give me the shirt, give me the person, and we'll find them.
So my question is, do you have a specific document? Because I mean, I do other things myself, and I've signed specific documents that stated that, yes, I'm here to golf or whatever I'm doing, but I take responsibility for any damage or if I hurt anybody. Is there a specific
I've done that on golf carts because we've run into issues where people have so much stuff to drink. We haven't done it on driving ranges, but if that's something, I'll have every practice and play member sign it, and everybody that comes in and buys a bucket of balls sign it. That's an effort from us that I'm willing to do. But when that goes down, I can't promise no golf balls. And that is what you're hearing here. 274 golf balls over a year period is less than one a day. That's easy math. I can't promise no golf balls. If they're willing to work with us to protect them, and I'm willing to help them do that. But I haven't heard anything on their side of it that they're taking to protect themselves. And I just don't think that quite frankly is fair in light of the fact that we're zoned and they're zoned for two things that are right beside each other. There should be equal commitment to protection. It shouldn't just fall on us. There was an assumption of risk. It's not express like you would at an ice skating rink to sign something and say, if I fall, I know I'm going to be liable for that because I signed that. This is implied assumption of risk, meaning you bought a home that was adjacent to a golf course. That's Kentucky doctrine. I know enough about that because we deal with it every day. It's implied assumption of risk. Now, where we could be guilty is if we're negligent, and I don't think we've been negligent. I just think there's only so much we can do within reason to operate the club effectively and deliver our customers what they want.
You're at a driving range and you got the tee and the guy's he's up there hitting balls, and these folks are living downwind from that downrange from that ball. They're in there doing their own business, and all of a sudden they hear a thump, or they're out working in their yard and a ball lands beside them, and they look out. It's 275 yards away. They can't be expected to see somebody, hey, he's got a yellow shirt, he's got a red shirt on, or they can't see that. I mean, that's way too far away, unlike a golf course, where it's quite a bit different.
Troji got hit from well over 250 yards away. The golf cart went in front of her house and she had the cart number, but she also has binoculars to be able to do those things. There's a property owner there that's 90 years old, not as get up and go as she probably used to be, but knew to took proper measures and trusted us to help her do it. And I don't get that from these folks.
The golfers are moving forward with and hitting their hole. So they're following that ball, whereas on a tee, they're just hitting a bunch of balls, right? They're just hitting a bunch of balls regardless of where they land, right? So they're just hitting a bunch of balls. Can you move that tee back? Can you move it back?
What you see at the behind of that, where the carts are on that picture, is the back of that driving range. There's no room to go back without going downhill. It drops off there and goes into our pool. So that's as far back as we can take it at this point. Now, again, I can aim it further north, but eventually that brings, now there's a ton of trees there in that picture that you can't see, but eventually, I'm sure those homes get hit too, but there's a greater tree canopy there. Those trees are 70 to 100 feet tall. The tree canopy on the right, which covers most of these guys' houses, is pretty good, but they're only probably 50 feet high. So.
Okay.
Yes, excuse me. You said that if these people would get the color of the person's shirt or something and give it to y'all would see that money was collected for the damage. Yet I heard this gentleman over here say his taillight was knocked out and y'all refused to pay the damage.
We did not hit the golf ball. So what I said was the golfer's responsible for that. If I replaced that light, anybody that came to me that said they were hit by a golf ball, I'm saying I'm responsible for that. And that's not the way assumption of risk has gone for golf courses. Golf courses, they pay a green fee just like they do at a bowling alley. A bowling alley charges a green fee essentially when you come to play. They get access to a lane just like we give them access to the golf course. That doesn't mean that we're responsible for that. If that bowling ball turned around and broke somebody's leg, the guy that rolled the ball is responsible for that, not the bowling alley itself. And that is the way it's been. That is the way it's been the entire time I've owned golf courses or worked at them for over 35 years. So,
well, I'm just saying that man did what he could possibly do, yet he got no relief. He is the one injured, and he had nothing to do with it. And I'm not saying he had a personal injury. I'm just saying
there's people all over the golf course that unfortunately have ball strikes. We work with property owners all the time. Again, there's 300 homes on the Oldham County side, and there's well over 300 homes on the Jefferson County side. There's over 600 homes that are adjacent to this golf course. I deal with this on a regular basis. This is not a lone prospect, and neither does any community, Hurstburn, where there are homes, Lake Forest, where there are homes along the golf course. There are ball strikes, whether it's vehicles, the property, or even sometimes individuals. Polo fields, Persimmon Ridge, they all have homes along them. This is not out of the ordinary, particularly in the 90s when these were built as part of communities.
Well, if that person who has the collar of the shirt at 300 yards gives that to you, are you going to make any effort to find out?
Absolutely. That's the whole reason I brought it up. We've done it in the past. What we typically get is somebody hit a ball in my yard, go fix it. I just ask for, again, a little help. If you give me a little help, I've been able to help other property owners. The Steele family and Dot Troji, I helped them. There was a gentleman that lived on number 7. He still lives on number 7. He constantly gets balls that work the other way, to the left, instead of downrange to the right. And he is in the place where if the tees are in a certain position, because you move tees on a driving range just like you do on the golf course, I couldn't do as much for him, and I think he took some action himself. I don't know what those are, but we don't hear from him anymore. I did as much as we could on the golf course. We've offered to spay trees and move them. Now, we don't have 100-foot trees to move, but I can move a 25 or 50-footer. And that sometimes helps the line drives, the ones that are coming this way. The ones that are coming in that are hitting 6127 are probably more irons. Anybody that's hitting 6127 that's not a driver, that's an iron.
And a learning golfer. That's quite a slice.
That is 100 yards offline. These are not houses that are like some of these are that I've in my career. They're right along the driving range. These are 100 yards in some cases off the middle of that driving range.
How many driving ranges do you own? You said you've done this your whole life. How many?
Every single time I bought them or managed them. I graduated college in 1990. I played for a living for 5 years. And after that, I worked at the polo fields. I ran different strokes when they started it. David Jones' son hired me to manage the golf course and all the different strokes ranges, which were in Florida, Melbourne, Florida, Tampa, Florida, Panama City, Florida, Memphis, Tennessee, and New Cut Road, English Station here, and down on River Road. After that, I moved to North Carolina, and I was a head pro there in 2 different locations. I managed two ranges there. the Carolina in Pinehurst, and the Bayonet of Puppy Creek in Rayford. I then was offered the general manager job at Forest Dunes in Michigan, in Roscommon. I then got the job in Brentwood, California, another driving range, huge driving range of 27 holes. I then got the job at the Presidio down in San Francisco, another driving range. I then got the job at Walt Disney World Golf, managing 3 golf courses with 3 massive driving ranges. So I'm very experienced with this. This is not something that I haven't seen before. So that's what I'm saying. I'm willing to take steps. This is not something I just backed into as I love a hobby and I want to do. This is all I've ever done.
So how many with the driving ranges have you implemented that whole $40, $80, whatever it was, where you're learning?
Everyone from the Presidio on, because that's where I learned it.
And have you ever run into an issue where that has?
Sure, we ran into it at Cincinnati. We owned one up until February called Legendary Run on the east side of Cincinnati that has homes much closer than this on the driving range. And we did the same things. We took the targets that were on the right side of the range, moved them left. We implemented a couple, we did have a camera up there, and we said, we think it's a good idea if you put netting between these 2 trees, and that's what he did. And we helped him find the netting. He was a member of the club, and his son was actually living there. He had bought the son had bought the home from the father. And in that situation, between 2 pine trees that were about 40 feet tall, he put up 2 poles and took some netting from us that we helped him get. I have not had one phone call from any of these folks that say, I get it, I need to do a little bit myself. Can you help me do that? And I will be willing to help you do that.
What would be the cost to the homeowner to put up netting? You said you had free nets, but I'm sure there's labor and things. What would
Look,
be
I'm willing to say today that if we can agree there's going to be balls in the yard, I'm willing to help as much as I can. Okay? And that's even to the point where what I'm not going to do is admit that I've done something wrong here. I want to be very clear there. But if they want us to sit down and say, this is over, can you please help solve this with us? I'd be happy to do that. I'm willing to commit thousands of dollars, I don't know how much it would be, to do as much as I possibly can, but I want it to be a back and forth. It has not been a back and forth. It has been, you're a nuisance. You're doing it wrong. You're negligent. And I'm here to say, look, again, it's the conundrum I said at the beginning. We've been zoned to do this. I am an experienced operator. I'm doing the best I can to run a business and respect the fact that you have a home. There are other ways to handle this other than the forum we're in now. They have never taken my offer to have me help. I'm willing to help.
Okay. What about, I noticed that these tee boxes, they're open. What would it be possible to put up like some sort of wall between them, or?
That is when they're on the mats. That is not, the mats are, again, in our business, if you're coming as a good player and want to hit, mats are not what you want to hit off of. That's when the turf is not good, or we're in the winter months when the grass isn't growing. So we could put them up. That wouldn't necessarily prevent every shot. It might prevent some when they're on the mats only. But when you're on the current tee
100-yard
line,
off mark, it would help that one because they're pretty well slicing that right off the.
well, you can see what Daniel's showing you is almost dead center of the driving range. So we have equidistant, well, actually more to the right, but there's some to the left also. So that's, you're looking downrange right down the middle. You can see how far to the right those homes are. They're behind a row of trees, and they're 100 yards offline. It's my contention and my experience that these are intentional hits. And we do have people that will do this kind of thing. It's hard to believe that every single ball they've experienced, in my opinion, and I'm an expert at it, and to Steve's point, this is a wild slice to the right. And it's going to happen. Now, if it's an accident, those are the people that are easy to fix. The morons that do it intentionally, we need some help.
What about, would it be possible to put up netting closer to the tee boxes that would be angled so that any balls that were hit that were sliced, they would more likely hit that net, as opposed to when they're at their highest point, say, or above the trees?
Again, I'm willing to consider something like that. That was not required when the zoning was issued for this classification. I want to know what they're willing to do to help also, because that net is not going to be 100%. And we are here today not because of thousands or millions of balls. We're here for a ball, 2 balls. That's not, you've heard them say that One ball is too many. I heard one person say that one ball is too many. Well, we're going to be here again, folks. I don't have 300,000 people hitting balls as I do on the golf course, but we're going to be here again. And so, in fairness to everybody in this room, including you all who have had to deal with this, and Adam, and those before him, Jim Urban and others, we need to find a solution that we all agree we're all not being negligent in our own responsibilities to protect both of our interests. Mm-hmm. And I just don't hear it enough, quite frankly, from the other side.
So when you implemented and I don't know what you called it. What was it when you implemented where more inexperienced golfers do the drive and
practice and play membership?
Practice and play membership. What kind of increase have you seen historically from what was there prior to after you implemented?
It's not a perfectly linear thing. In some markets, people like to hit balls. Some others, the play component is more important. It's practice and play. It's been very effective. It's in the afternoon. Most golf courses aren't that busy in the afternoon. The people I worked for taught me this, and it works really well, and it makes golf courses successful. And so, are we as successful as we want to be? No, quite frankly. I'd like to be doing a little bit more to support the people behind me. Some of them are very avid members and have supported us through the good, the bad, and the ugly. And I'd like to be able to continue to look, the more the prices go up, the more that I make the golf course more valuable, some of this nonsense goes away. You don't see this at places like Valhalla, and you don't see this at places like Forest as much. So, but I got to bring in income, and sometimes you have to charge a lesser price. When we started this program, it was $29, $39 a month. It's now at $69. So those rates have gone up. And that's an indication that we're doing some things right. You don't take the price up when you're doing bad because nobody's going to buy a bad product when it's bad. So to your point, as it goes up in price, there's usually less activity.
Well, what increase did you see? That's what I'm trying to get to.
I can't. I think Daniel would be able to speak to it better. I don't think it's been as measurable as what I've seen at other locations because we're not already on our main street. The courses that do better, from my perspective, are like the Presidio, which are right in the middle of downtown San Francisco. If you have a driving range that's open, it's going to be busy because everybody has access to it. This one's been, a mile and a half back in the neighborhood. Not everybody's figured out that if I'm not a member there, they'll at least let me hit balls. And our idea then is to try to get them to be a member. We don't advertise that it's open to the public for the driving range because we're doing everything we can to balance. We have a private and a public side to this that both makes us successful. But when they come back there and say, can I hit balls there? We're going to say, sure. And we'd love to have you as a member. It's one of the ways we've invited people to the club that may think we're a private club. Most people that come through our door assume we are. And it's been part of my job to try to get new members. The only way you can do that is to get people to come try it. So I don't have a perfect number. It's nowhere near the confluence of what I'd like to see. I'd like to see it busier, which is why I expanded it in an area that aims further away from these houses.
Okay. Any other questions?
Yeah. You got a question?
Go ahead.
You being the expert that you communicated, when you first acquired the golf course, it was irons only, right? Is that right?
When I first acquired it, that's what Pac Life had decided. In talking with Daniel and the team there, it wasn't always irons only. There was an assumption when the way they were talking that that's the way it was from '93 till I bought it. That was not the case. It was anything you wanted to hit up to a point. Now, when Pac Life did that, I don't know. But we sat down with most of these folks, I think right in 2016, right when we got there. And we started making some of the adjustments right away. And it just has never been, it's never been enough.
Tell me again, I think I missed it. I did in my notes if these folks say it was irons only and you weren't really 100% sure it was irons only when you acquired the golf course.
It was irons only when I acquired it.
It was irons only.
Correct.
So with your expertise, you knew that this would be coming up, right?
No, as Daniel said, it was irons only when they were ahead of the tee box you're seeing here. Those ones we took out. They're not even there anymore.
Okay.
So those ones can be hit from the front tee boxes that we don't use anymore. You could hit every house with that, with an iron,
And
really.
So why did you, I think you said that to increase your membership or so, you went to woods. Is that right?
Correct. A driving range is called a driving range for one reason only. If you go to Top Golf, you're not going to see many people hitting irons. They're going to hit drivers. But many of the houses that are along here are being hit by irons as well. That's my point is I wish I could manage to zero tolerance. I can't. There's no way, whatever we do, there's not going to be a ball in the yard. So there has to be some come together and say, we're going to work together and try to solve this problem as best we can, but I can't promise zero. I mean, if we're going to do that, we might as well talk about other uses for that property. That's not fair to them if we're telling them it's zero's the number. And what is it, 5? Is it 3? I mean, there's no way to promise what that number would be. If it's zero tolerance, then we need to be talking about different uses for this property.
Okay, I just have 3 quick questions. So the first off, in the agreement of going to the irons only that you all had made verbally with Jim and everything, you had already answered this part of the question earlier that you had gotten complaints from the members. Do you know if there's any sort of data on the number of members that you may have lost, or was it just complaints?
Yeah, it's just complaint. I can't speak to that.
Okay.
But I'm not going to offer that any further. The practice and play membership and our full members, some of which are behind us, want to go out. They're paying $300, $250 a month to hit every club in their bag. That's part of what we offer, to be competitive with every other club in the Louisville area that offers the same.
Okay. All right, the second question I have is you had made a statement of talking about, the residents are willing to help and, you'll be willing to help them. So my question would be on some testimony that was given earlier. They said one of the last text messages from the text message line was, sorry, you moved next to a golf course. And my question would be is if you all are willing to work with the neighbors and they say the text line is a good thing, why? And I don't know if that was a comment that was truly given or not. We haven't seen that in writing, but
it very easily could have. I mean, quite frankly, I think our just like they're frustrated, some of our team is frustrated. I don't know who they talk to. I would hope it's not Daniel or I would have never have said that. But we also have young kids in there. Is that the most responsible thing to say? Absolutely not. And I'd love to know who that was, because I'd give them a tongue lashing for that. We don't purposely do that kind of stuff, and we take action when we see it.
Who was on that line? Who all could text?
It was all the homeowners, Daniel, and I think several other people in the golf shop.
So would it have a name to who made the text? Well, it looks like he's got it. So maybe we can see if there was a name to that.
Hold on.
Does it have a name on it?
So there's you bought a house in the driving range. This should be interpreted as helpful bit of information.
Turn the light off.
Well, okay. We know who Andrew Dixon is, and we'll talk to him about it. I have no problem doing that. There needs to be a measure from both sides to be reasonable. I think the frustration from the golf shop side is that they're getting these calls regardless of no matter what the situation is, no matter what we've done, it's always coming in. So the text line was not solving it. And I think the frustration they probably came from Andrew is what Daniel feels more than anybody. This just never stops. So I'm kind of glad we're doing this, because at some point there has to be an agreement that reasonably there can't be zero balls. So what are we going to do to mitigate it as much as possible? We're going to do everything we can. I'm willing to commit money to do that. What are the homeowners willing to commit to also do the same?
Okay, and my third question is, and I'm solely going to ask this one only because it was asked of the nearby homeowners about property values. And so my question would be, in your experience operating courses, if the course were to close, which I think everybody in this room hopes that doesn't happen,
correct,
does that also affect property values? And I think about Indian Springs, I think about Glen Mary, and so
yeah, just go by Indian Springs and tell me if that's worth as much as Glen Oaks was, and they were probably equal value when they were open. Ask how Glen Mary's doing. Go out there and see the dust bowl that's behind those houses. So we're not in any, thank goodness, in any shape like that, but this isn't going to help if we can't have this as a driving range. You've taken away one of my tools to make the course profitable.
When you have a golfer at the golf on the tee, and do you all tell a specific golfer when he comes to say, I want to go out and hit some balls, do you write his name down? Does he know exactly where he goes, and you have a idea of exactly what time that he's starting to hit? You know, so
I mean,
that
I
way-
think it's a great question. I think we have better idea than I've ever had in my career. I've never seen this before. So if it's a practice and play member and we sell them a driving range token, that is usually rung up on their account. So as a zero, we have to pull them up to make sure they're members. So, and the same with our full members. If it's somebody that walks in that said, hey, I've never been here before, I'm new in town, I've moved into Norton Commons, I may not know who they are, but I'm willing to do that. It's a step I'm willing to take if I hear what they're willing to do to protect themselves as well. Because we've both, again, the conundrum is we've inherited this in some way. It's been zoned for us to do this. We are not being irresponsible, but I'm not hearing anything. In all fairness, I'm not trying to be belligerent here. I'm just saying I have not heard anything, and neither of you, that they've done anything. And that assumption of risk is implied. It's somewhat expressed because it is in their homeowner documents that there's going to be a recreation space there. It's clause 31 of their CC&Rs that they had to sign, no different than they had to follow everything else that's in those documents. And it says clearly that the golf club or whoever owns the golf club is going to be doing recreation activities that are associated with the club's policies. That's about as express assumption of risk as you can get as a liability waiver. So it's almost two. It's close. So we have implied assumption of risk and express assumption of risk. Those are the two things that are in the Kentucky assumption of risk doctrine. Again, I'm not trying to be belligerent here. I'm just asking for equal effort to protect property and personal injury, and I've done that everywhere else.
Thank you.
You're welcome.
I've got a question. I think on both sides I heard the word intentional. Do you feel like you have golfers that are intentionally hitting balls?
Well, I'm certainly not recruiting them, but yeah, I think so. I just don't see, if you look on this picture and you say, hey, I'm going to hit at the brick I see in the background, that's the middle of the range. And to know that Mr. McNott's house is literally over that bag stand on the right. It is over and to the right of that bag stand. That is 100 yards away from where our target. None of our targets are to the right of that brick you can see in the background. That's a significant shot to the right. I'll give one guy a shot. You know, if you're doing it and you hit a terrible, let's hope that most people aren't intentionally thinking that's funny. But there's no way you can't say that's intentional at some point. Now, the ones downrange with a longer shot, probably maybe a few more of them are unintentional. But the ones where Mr. McNatt is, that's not a driver, and that is, sometimes I bet they aim at the chipping green, which you see in the background there. Those are not, there's somebody actually chipping over there. You can see it in the picture. And I bet that they probably aim over there. And again, we've taken measures that if we see that or can see that, we take action. But putting somebody up there is a $50,000 decision. In the number of days we're open, times $10 or $12 an hour to stand there and do nothing else. That is not the best spend of our business money at this point. I'm willing to do some things, but that one right now isn't sensible for what we've been allowed to do. That's not normal in the driving range. I've never seen that anywhere. You can call any golf course. Nobody has somebody standing on the range making sure nobody hits it unintentionally towards a house. Now, they do other measures, and again, I'm willing to do that. I'm willing to spend money to do that.
Sounds like you support better communication with the text thing that's been.
That worked really well for a while, and then they just continue to go, and that's because any ball that enters the yard is unacceptable. That I can't measure to zero complaints. On this particular example, I can't do it. I can't measure to zero complaints on a hamburger. No different than this. What's that?
How does the text chain prevent balls from going into somebody?
It doesn't prevent them. It's a lag measure, right? It's already occurred, but it allows us to imply to that person that hit it that you either had property damage or personal injury damage. And that's why I gave you both examples. The Steele family and Troji, they experienced possibly two different situations, of which I'm willing to remedy and help remedy. But I have to know more information, of which we're the only ones gathering at this time.
But that's not going to prevent balls from hitting houses.
That's my
It's gonna-
point, is
Right.
we either have to realize we can't manage to zero balls, or we're going to have to find a different use for this property. But what I'm not going to tolerate is that it just sits as a field. 10-acre field in Oldham County is not what I purchased, and it's not what I'm zoned to do right now. So if we're going to, there's only two ways this can go. I'm a property owner in Oldham County, no different than they are. So if we're going to deem that a driving range can't be done there, which I don't agree with because it's going to hurt my business, then we need to talk about other uses.
Yes, sir. All right. I think we've asked enough questions of the property owner. Did you have any comments you wanted to add to it?
Thank you.
sir. No, you've said it. You're good.
Some of the questions that you all have asked, Jamie's not on site to answer every single one. I'm not going to say correctly or incorrectly, but going back to the text message chains. So we can all be clear on that, is there are days when those text messages from the homeowners are coming. Mr. Cooney or Mr. Saylor implied that he would like a response within 5 minutes. Have either one of you responded to a text message today in 5 minutes while you're at this meeting? I have a business to run as well. I can't just live on my phone if I'm trying to manage a pool, a clubhouse. Property's 250 acres. I'm on the south side of the property. I can't be at their house within 5 minutes or answer a text message in 5 minutes. I have 2 other paid employees on that text message. There are 15 to 20 of them on that chain, 3 of us. It's not feasible. There's days where it felt like harassment. So when they filed for the citation, I felt like I haven't done enough for them, so I ended it. I told them that. As of today, this text message thing is done. I mean, I have put cameras up for them. I have many meetings with these folks on our property, in our clubhouse, with Mr. Urban and Adam. We have done, as Jamie has said, we are the only ones putting a foot forward to help. They haven't done anything. We've offered them free netting to put in their houses, around their houses or in the trees, whatever. They have not taken us up on one item.
Any questions? All right. Thank you. Thank you. I wanted to give the homeowners a chance to, did anyone else over here? I'm sorry. Yes, sir. Let's let him speak real quick, and then we'll get to you, sir.
Jack Cooney. One thing that hasn't been referenced to, and although obliquely, Jamie mentioned that you don't get these kind of complaints at Valhalla and many other places. I'm sure that's accurate. I'm sure it's true. An inherent problem with the driving range is it's extraordinarily small. The acreage requirement for a driving range in Oldham County is 20 acres. This isn't near it. It's probably 12 or 13. And it's legal, but it's non-conforming. And it's really non-conforming. To become conforming, which it won't, but just to put it in perspective, it would have to increase by about 1/3. That's a big part of the problem, right there. The range is just too small. Reference was made to that in the HO documents that there's recreation that's going to take place. That's true. Also, in those documents, there's reference to the club, pools, tennis courts, no driving range. It's not mentioned. Now, this is years ago, and I realize today it's legal and non-conforming, but it's not mentioned at all. We had been informed about netting and the offer for the netting, and we appreciate it. A reference was given to us of someone who had used the netting, and I visited that home, as did others. And that situation was a homeowner was getting hit by low balls. It was a dog leg left, and hitters, I should say, were trying to cut it while they were going into the trees and then getting on the property and hitting a house. That's not our situation. Certainly in my situation, if I'm getting them, they're coming in way high. Netting's not going to work. So,
Would you entertain netting?
pardon?
I mean, I imagine netting would have some effect to balls coming in.
I don't know, because I've got large trees in the back that provide a lot of protection. So when they do come in, they're coming in way high. Well, it would have to be netting like at Top Golf, if you've seen that. That would work, but that would also destroy our property values. So
You could be able to say that you don't have a golf problem in hitting your home and be truthful about it if you had nettings that big, right? You wouldn't
Yeah,
be misleading
well,
anybody.
yeah. If, I should just ad lib here, if irons only is out of the question, and if using text messages is out of the question, we've gone backwards. Since 2022, we've gone backwards.
Well, I want to make sure that everyone understands our job is not, we can't say they have to use iron. I mean, our job is what's in front of us is that the use of the property
Yes.
is detrimental, dangerous, things like that.
I agree. And I did think it was kind of incredulous to hear that balls landing on our property were the factor that causes it. That was kind of interesting. Thank you.
Yes, sir.
Hello, Mark Liesinger, M-A-R-K, Liesinger. I live at 10609 Worthington Lane, and I back up to the driving range, which is our topic today. My personal concern in coming here is that we joined the club in 1999 when we lived in Goshen, and we bought our house in 2003. And like everyone else, we bought it for the same three reasons: location, location, location. And I would hate to see my view out the back of my home go from being a driving range and trees to a cul-de-sac. So I am, that is my concern. I just wanted to point out one thing. Could you bring the picture up of the driving range? And, it's over here. Sorry. Okay. I want to point, oh, it's not going to point out. In the bottom of the screen here, you see what's now, there's a swimming pool here now. Then you can see that there is a sand bunker. And then the big tree is in the back right corner of my home. There used to be, and I guess I don't have a pointer here, if you, look at the, that's the practice chipping green, and there are some trees there on the, just below where the blue line goes left of the chipping green. There used to be a bunker there, and when Pacific Life, they hired a company called OB Sports to manage, and when Mr. Leisenring, there was a bunker there, and he said, how do we stop people from hitting the houses? And I said, well, when I joined the club, we were told that bunker was only for hitting towards the range. He said, so we can get rid of that bunker. So we got rid of that bunker. It's grass, and it was a solution. So I've been encouraged by the meeting today that there was talk of solutions. And my wife and I walk past these people's homes. We say hi to them. And I would really like for this to be worked out and not have this change. And yes, I am a golfer. We seniors are out there at sunrise, Tuesday, Thursday, and Saturday morning. And I'm the longest hitter of the seniors, and boy, I'd have a tough time hitting one of those houses. My 76 years have caught up to me. But if we could eliminate teenagers from this world, we'd have less car accidents and we'd have less golf balls in backyards. Thank you.
Thank you. Anybody else? No, you're good.
My name's Robin Saylor, and I live at 6123 Laurel Lane. I'm married to Scott at the end. We have been there 26 years. And like I say, and like he said, that we didn't have very many issues. Plus, we didn't have very many houses. We were like at the end of the street, and then they started adding the houses. So we started having an issue after probably in 2016, 17, something like that. And whenever we had somebody hitting the house, because I would go out there and mow grass and somebody almost hit me in the head. So I rode over there. I was told I could not ever do that again. I had to leave their property, okay, the range. I had to leave it, and I could not go over there again. We have been told we are not allowed to come over there. So I like to know how we're supposed to look and see what color shirt they have when we're not allowed to go over there. Does that make sense? Right? Am I right? Yes. And Daniel has been wonderful, honestly, through all this. He's been very helpful. We have not been mean or malicious. And my mom is 88 years old. She is staying with us right now, and she loves to go out in the sunroom. She loves to sit out there because it's peaceful, but she has got a little nervous when we got hit. The problem is you can hear the ping of a ball, and I take it, I'm not a golfer, that's a driver. Am I correct? When you hear a ping, everybody says that. Anyways, it goes over the trees into our front yard. It hits our trees. Oh, another thing, we planted 2 river birches. I don't even know what year it was, maybe 2005. They are the fastest growing trees, and they have protected our home. So yes, we did protect our home. We have worked at things. I picked up mini balls and thrown them out onto the range so you all don't have to come on our property. So I don't understand why you're saying that we don't help out.
Hey, ma'am, make sure you direct your comments to us.
I'm sorry.
Yeah.
All right, I'll focus. But anyways, I just feel like that we want to be neighbors. My husband does not like being there anymore. He got really sick during COVID. He was a nervous wreck, okay? I didn't want to move, but we have put our house up with a real estate agent. I don't want to move, but we have. And guess what? Y'all have a golfing problem? Yes, we do. We have to get that resolved before we could put the house on the market. So that's what I'm saying. We need help, because we all need help on it. So.
Yes, ma'am.
Do y'all have any questions?
Okay, that would be a great point to stop and allow me to kind of explain the scope and the limitations that the board has. I'm the attorney for the Code Enforcement Board. I'm not a member. I don't vote. I don't take positions on each side. My requirement is that I provide good legal advice to the board so that any findings that are made today are defensible in court in case somebody wants to appeal. So it's natural for both sides to want to vent and put emotion and history and that kind of thing on the record, and I did not want to interfere with that, but it's my understanding that everybody is finished, so I need to bring us back to really the reason why we're here is for the Code Board to decide only if what has been described in today's hearing as a violation of the nuisance ordinance. It's very important because Mr. Miller repeated some phrases and concepts that are not foreign to me as an attorney, but may be foreign to the board members or maybe even the witnesses. For example, negligence, assumption of risk, deed restrictions, zoning, those kind of things. Those kind of things are not going to be relevant in today's deliberation or findings. The only thing that the board can do is consider the facts that were proposed, and if there were competing facts, the board has to decide who they believe. And that's all I'll say on that. then they have to apply those facts to the nuisance ordinance, and even more specifically, to the notice that was provided to the property owner. Unfortunately, today's not mediation. Today, there's not going to be an agreement between property owners and neighbors. That's not what the purpose of today's hearing. So I think there may be some room for that, but that would be done somewhere else.
Sure.
If the board upholds the fine, then it doesn't really mean that there's a requirement for anything to change, but it does provide notice that the golf club is subject to being fined again. So if the board votes to uphold the fine, there's really no availability to order the golf club to do anything. That would have to be done by a circuit judge in a serious lawsuit. It's not something that the board can do. And simply put, if the board upholds the fine, it's not the board's responsibility to tell the property owner how to resolve it and how to prevent it from happening again.
Sure.
So at this point then, if all the questions have been asked, then I would suggest that the board either enter into some discussion among themselves or entertain a motion.
Can I be excused? Thank you.
Okay, I'd like to open up for discussion. And to the point, let's stick with facts that pertain to the citations, specifically rendering the property as dangerous or detrimental or adverse to the health or welfare of or offensive to the senses of residents of Oldham County. Do we have any discussion?
Yeah, I have something. Hang on a second here. Let me get that back up. I've heard a lot of different, I heard everything, but I underlined detrimental or adverse to the health welfare. It only takes one ball to really hurt somebody, really, really bad. And so that's what I would consider is it's never going to go away until this is fixed. So,
yeah, and I think that, to the point there is it is true. As long as this is used as a driving range, the idea of being hit with a ball is not going to go away.
Right.
Any other discussion?
Yeah, I agree. It's never going to get to the point where there's no balls going in anybody's yard.
So some of the things that I noted, it appears that the course is, looks like they have made some changes to try to make things better. Obviously, based on the testimony, they seem willing to work with people to make improvements to that. Even when I said, "Is this possible?" It was responded willing to talk. So I would take that on face value that there is a potential solution that could be reached between the people. I know that with a driving range, I mean, if we're talking facts, I mean, I don't know anywhere where there's a driving range in the country where balls being hit in the yard would be considered a nuisance. Because if we did, we would see that everywhere. So we have to ask ourselves, is the idea of having a driving range, which we would have to assume that it is legal to run as a driving range based on zoning. So they're not breaking that law. So that's.
But as long as the golf balls or a golf ball, I know we can't guarantee any golf balls not going into the yards or hitting the house, but it is danger or detrimental or adverse to the health. So it's no matter what, if the the golf ball still hitting the house, still going in the yards, are still going to meet that nuisance clause.
So what we're saying with that is, by the letter, quite literally, of the law, since it's written the way it's written, you're saying that it is a danger just on the face. Would that be correct? Okay.
With balls going anywhere in hitting the house, going over the house, hitting the cars, going in the street in front of the house, back of the house. It's like there's a constant opportunity for something to happen.
So the competing thing in my mind is you have a business use that is zoned appropriate, for this, whether it's appropriate or not, it's not up to me, but by the sheer use of it.
But if it was zoned, that's the question. When it was purchased, it was irons only, and they didn't have this problem. And that was, I'm not an expert at driving ranges. That's the reason why I asked the question.
Yeah, and it does appear that they acted on that as it was irons only for a while, even though it was a verbal agreement. That they do appear to have adhered to it.
And it slowed down, right?
Well, and I would say it also slowed down before they had lowered the cost. So that's another thing that would be a fact is, as a business owner, you're trying to make as much money as you can. And one way you do that is by, creating a more diverse or a generic item, or a more specific item. So when you're talking Valhalla, and it's thousands of dollars to get on that green, you expect a better class of golfer.
It's incumbent. Isn't it incumbent of the owner to do it within the scope of the law, right?
Which I don't. Yeah, and I don't think lowering the price to get more people in the door. You know what I mean? I think that was a business decision, and I think the effect of that is you have more golfers and more novice golfers, and I think that would reasonably explain the uptick. And certainly telling someone you have to charge more or you can't charge that low amount, that's outside of our scope. So, any other discussion?
Yeah. Our role is to determine, are golf balls going into people's yard, hitting houses, hitting vehicles, a nuisance?
Was that question directed at me?
Wasn't really a question it's a statement for me.
Okay.
Because we're looking at the violation of the ordinance. The ordinance it's a nuisance ordinance. Are golf balls going into somebody's house or somebody's yard, hitting the house, hitting vehicles? Is that a nuisance?
That's the whole question for today.
Yes.
Well, I think the people kind of determined what a nuisance was whenever, as long as they were hitting irons, everybody seemed to be okay. But when they switched to woods, people are no longer okay. Now, the statement was made that these people could assume when they bought these houses that there would be golf balls coming in the yards and everything. But I think the owner could have also assumed when he switched from irons to woods that there'd be more balls going into these people's yards and things and hitting their houses. So, personally, I find it to be a nuisance.
See, do we have any other discussion before we move to? All right. First item that we have to do is a procedural one. We have to determine whether or not this citation was issued properly. So I'd like to entertain a motion that the citation was properly issued on 8/19/2025 to the owner occupier of the property.
I'd like to make a motion that was properly done.
And that they requested a hearing. We saw detail of that, and they were here to argue that. So your motion was to that effect. Do we have a second?
Second.
Okay. So all for that motion that the citation was properly issued, say aye.
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 Opposed? All right, so we have passed that it was properly issued. So the next matter that we need to create a motion for is whether or not a violation has occurred. So would someone like to make a motion to the effect of the condition and whether a violation occurred?
I'll make a motion that the violation is still occurring based on as the balls are being hit into people's houses. I mean, as a safety.
So your stance is that there is a violation.
Yes.
That it was observed by the officer, and it's continuing to do so.
Right.
Okay. So we have a motion on the table that this was a violation, and that it was observed, and that it does meet the county ordinance for a violation of a nuisance.
I'll second that.
All right, we have a second. All in favor, say aye.
Aye.
All opposed, nay. So the ayes have it. The motion is passed. So now that has passed, the next is going to be what we do with the citation as far as the fine. One of the items then is, since a violation has been determined, we need to determine what we would do as far as the fine is concerned. Do we uphold the fine, reduce the fine? What do we want to do? I would like a motion for that.
What is the fine now?
And if you need to discuss, do you want to open it up for discussion?
Yeah, I would like to open.
Okay, we open for discussion. What should we do about the fine?
I mean, these guys are they want to work with the residents, and they're eager to find a resolution as well. And but I know that being in violation, there is a fine, but I think that I don't know. I mean, I'm putting that out for discussion. So, I mean, what is the fine now? What is the fine now?
So the current fine is for $150. And to let y'all understand, so every day of the property being in violation could be assessed. So this fine was for $150. If they are in violation tomorrow, it could be $250. The next day it could be $400, and every day after that could be $400, unless you all give them time to work out a resolution, a distance, an amount of time to have a resolution with the homeowners. You all do have that option, and then the fines will pause until that resolution time. I will not issue another citation until after that time. Okay. That is your all's discretion.
Not 150. Is that uncontested? Does it differ?
So it's 150 because that's all that I put on this citation. I know we discussed that in that last meeting, but this was done before that. So from this point forward, contested citations will have an increased amount, but for this one, it's still just the 150.
Okay.
What about just giving them a couple weeks to find a good solution? There's been a lot of solutions talked tonight, find that solution and then,
I think a couple of weeks may be a little on the short side. I think we may need to give them a bit more time to
what do you recommend?
what about 30 days, 60 days, somewhere around in there? Do you think I'm looking for nods on something like that, 30, 60 days? Yes, sir.
So, and Matt, could I make a recommendation?
Well, like I said before, there are limitations on what can come from this meeting.
Yeah.
What I hear is that there's an idea to suspend the fine conditioned on some cooperation among the parties. And that's certainly acceptable as an outcome here, but we can't change the season. I mean,
Well, so, and that's where I wanted to make the suggestion, because obviously winter time's coming up, and I think they all agree that that time slows down. I believe it starts back up in around March or April. So I understand them coming to a solution, like you said, 60 to 90 days, something like that. They have to meet, come to a solution, and then we will not know if that solution until sometime next year. And you all can
I see what you're
determine
saying.
that time.
We need springtime so that they can see if there was an effect and it had the intended effect, any solution that they've reached.
Correct.
Has had an effect. I can see that.
So that's going to be,
no.
To Clayton, your point, what is the intended effect? That's the way you stated it.
And that's a very good point, because we can't say what the effect would be. I mean, for us, essentially what we're saying is the property needs to become within compliance of the ordinance. So that's really the extent of our order, is it needs to become a compliance. But keep in mind that the ordinance doesn't describe specifics as far as, so what constitutes a danger. It is pretty ambiguous on that. So for us, it would be, how much time do you need to be able to reach some sort of agreement?
Sure.
And then, in my mind, getting in compliance would, since Adam received complaints, I would imagine that if you have reached an agreement and they have seen the desired effect, we're going to know whether it's in compliance. If they're not, I mean, if they're complaining on 0 balls, I guess at that point it wouldn't.
I mean, there's no real oversight. There's no review in the future. It's just a matter of, are there new citations?
What incentive do the homeowners have to work with us if they know they don't have to work with us and we'll just be fine?
Well, there's no requirement that they do anything. If the board has
Exactly, and they know that.
right, well, I mean, it's your property, so.
Right, and we've been zoned to have a driving range. Sounds like we're going to court.
So at this point, there's been no motion or second or vote on holding the fine in abeyance. So,
Well, and I think to his point that what's going to constitute him getting it back into compliance if no matter what he does, they're still going to complain? And I think that's where that question was. Is his recourse then just court?
well, I think he's going to, indicating he's going to appeal the finding.
Yeah.
But it's not the board's responsibility to tell him how to comply with the ordinance. It's not the adjoining property owners to tell him how to comply with the ordinance.
Yeah, and I'm glad we don't have to determine what that would be. I mean, This is the hardest one I've ever had to witness here.
Well, that's the reason why I said 2 weeks. I mean, because they pretty much know what's on the table. They
I just don't know
They know
that-
what happens. They know the balls are hitting the houses. They know what constitutes the balls hitting the houses. They know that it's zoned for a range, but that range only has a certain capacity or
Yeah.
capability, and they know it's on the table. So they make either they want to take this to the court again, or they they pretty much know. I would think they would know what needs to happen.
Yeah, my issue with the 2 weeks is the compliance, because I can see the residents having an issue of, say, we reach an agreement and that agreement takes several months to actually put in place, say netting. I can't imagine that's going to happen in 2 weeks. And then if it doesn't have the desired effect, 2 weeks may not be enough time to bring it into compliance, because that's really what we're saying. You have this time and we'll hold it in abeyance. And if it gets in compliance.
I don't have any problem with more time.
But even on that note, on the zoning regs, and we've talked about that, when the driving range was built and it zoned appropriately, in 2023, new regulations were written for the golf driving ranges, which he alluded to the 20-acre minimum. But in that, it specifically says, fences, planting, or sufficient areas shall be provided to ensure the safety and protection of persons on all adjacent land. But then the very next point says, in no circumstances shall nets be used to fulfill the fencing requirement. So their hands are even tied from the fact that fencing, from their aspect of the golf owner and operator, can't put that up. The homeowner, we don't have any regulations that say a homeowner can't erect a net on their property, but the golf course itself can't use nets based on our current regulation. Now they can create a fence that's 60 feet high. I didn't write this, and I haven't seen a 60-foot tall fence, but they can do a 60-foot tall fence, and that's allowed. But netting isn't allowed from their aspect. So it's not as easy as just, hey, 2 weeks, come up with a plan and erect a net. I mean, I think it's going to take a lot of talking among the parties to try to figure out the best solution.
Yeah, I definitely think that spring is probably closer to realistic as far as coming to a plan, implementing a plan, and determining that it was effective. Would anyone disagree with that?
That's fine.
So trying to put it into terms, I would like to entertain a motion that California Dreaming bring the property within compliance of the nuisance ordinance by May of 2026. Do I have someone that makes that motion?
I'll make a motion.
Do I have a second?
Could I make a motion to amend the motion? I'd like to amend it by saying that it should be by May 1st, 2026.
Agreed. That stands amended, May 1st of 2026. Can I get a second? Or
You get a second.
Okay. Well,
Okay,
you issued the motion, so I need a second for that motion.
I'll make a second.
You hit the second for the motion. So all in favor of California Dreaming bringing it into compliance by May 1st of 2026, all in favor say aye.
Aye.
All opposed, aye. All opposed? We have one opposed. Which one were you yes or no?
I was a no.
Did you say aye? I heard aye over here. I didn't hear.
He said no.
Okay, so we have 3 yes and 1 no. So the motion carries. California Dreaming, you have till May 1st to bring the property into compliance. And then that would conclude. It's held in abeyance. Yes, it is held in abeyance until that time.
Mr. Hudson, Do we have any legal remedy while this is going on?
Well, I can't give you legal advice, but I can tell you what I think the board has decided today. So you're not going to get any more code enforcement citations
Correct.
between now and sometime, hopefully never, but that availability would not open back up until May 1st, is the way I understand it. So that's the benefit the board has given you. But other than, I mean, I can't give you legal advice.
Fair enough.
All right, so the next item on the agenda would be old business. There is no old business. Okay, is there any other matters before the board? Okay, hearing none. Hearing a motion to adjourn, do I have a second? All in favor say aye.
Aye.
All opposed? We stand adjourned.